In the United States District Court for the Northern District of Mississippi, Matthew Oliver Reardon, the plaintiff, versus Olive Branch, Mississippi Municipal Court and the State of Mississippi, in cause number 320-CV-00327-DMB-JMV. This is a proposed amendment to complaint. The background in plaintiff and basis of complaint is as follows. Your currently pro se plaintiff is Matthew Oliver Reardon. Reardon is currently 33 years old, as a United States Marine Corps veteran who enlisted in December of 2007, discharged in May of 2011 under a general discharge for alcohol rehabilitation failure. The plaintiff witnessed a gruesome suicide in Marine combat training, which led him to self-medicating through drinking alcohol. Reardon is married. He and his wife Madeline parent and raise 3 minor children full-time, and plaintiff's minor child from another relationship every other weekend, in a perfect world. Reardon is currently unemployed and financially fatigued from having to fight 7 different court battles pro se concurrently, without the assistance of an attorney, nor the financial means to hire one, as he has had to file everything in order to prevent being time-barred, to appeal everything and effectively restore his life and what all had been taken from him on what he alleges was a false arrest and false imprisonment, stemming from a knowingly false charge that was conspired upon and acted upon by individuals in the government, law enforcement agencies, quite possibly courts. Plaintiff has only sought the equal protections under the laws of the state and congruent with the United States Constitution. After all, plaintiff made a lifelong sworn oath to uphold and defend the Constitution against all enemies, both foreign and domestic, to bear true faith and allegiance to the same, and to obey all orders of the President of the United States. That oath never expires. On December 11, 2020, plaintiff Matthew Oliver Reardon filed a civil claim with this honorable court seeking preliminary injunction relief for protection against Olive Branch Municipal Court, along with protection from other state agencies, municipalities, and courts due to valid serious concerns that the plaintiff was being targeted due to him bringing forth indisputable evidence of Lafayette County government employees, including duly appointed law enforcement officers acting under color of law. This also involved elected and/or appointed officials tying back to the current mayor of Oxford, Robin Tannehill, and private individuals that conspired to frame the plaintiff for a crime that would have been an impossibility for a plaintiff to have committed, in a combined effort to disarm, silence, and get rid of the plaintiff, then further attempt to shield their own liability by way of utilizing the help of others. All of this, the plaintiff claims, utilized the help of more and more in order to fix or cover their tracks and spread further and further into the web branches of government. Mainly the state of Mississippi, but even federal. More recently, the Federal Bureau of Investigation's Public Information/FOIA officer admitted via email that the Bureau could not locate a 302 report, which was requested by the plaintiff approximately 6 months prior, in regards to a sit-down meeting he had at the local field branch office in Oxford, Mississippi, the day before he was arrested in the conspired upon intentional attack to effectively conspire to remove the civil rights of the plaintiff, which was then executed through and through. Plaintiff sought out protections from the Federal Bureau of Investigations on May 25, 2017, after speaking with Assistant U.S. Attorney Bob Norman of the U.S. Attorney's Office for the Northern District of Mississippi on or around May 24, 2017, in regards to plaintiff receiving information to a death threat that had been made on him, along with Ray and Robin Tannehill taking out an injunction against the plaintiff, effectively barring him from speaking at City Hall on June 6, 2017, which just so happened to be the day of the mayoral election in Oxford, Mississippi. This was the turning point for which Lafayette County effectively panned large-scale from the constitutional attack aggrieved at the plaintiff on May 1, 2017, when Deputy Timmy Pruitt arrested the plaintiff for disorderly conduct due to him simply standing on public property holding the state flag of Mississippi on the Oxford Courthouse Square, not having a permit to protest. This interaction was reported on by numerous news stations and publications, along with the video interaction going viral on social media. Plaintiff had a meeting with two FBI agents in Oxford on May 25, 2017 at the local field branch office in Oxford, where he discussed this with the two agents, discussed and showed proof of the death threat made against him, and discussed what plaintiff felt assured was a highly immoral and possibly, quite likely, even criminal move by the mayor-elect of Oxford, Mississippi to suppress the plaintiff from speaking and addressing key grievances prior to an election, and was already listed on the public agenda, was already listed on the city board minutes, which is published in the local Voice news circulation. Plaintiff will always maintain the same stance of this being something that should come as a fundamental right to all citizens in America, 100% backed and protected by the First Amendment of the United States Constitution, specifically to petition the government for a redress of grievances. However, after the extreme amount of civil liability continued to climb more and more through the highly contentious arrest made by Lafayette County Sheriff's Department May 1st, 2017, which in turn created liability for the county itself as well as the state of Mississippi, plaintiff alleges it was then that a conspired upon plot began amongst a group of co-conspirators that would each uniquely benefit through a successful and well-executed attack on the plaintiff and fully depriving him of his rights through the combined help of others. Plaintiff has maintained the same stance that his minor child had originally been yanked away from him based on a false petition by plaintiff's ex-girlfriend and mother of his minor child, which sought emergency injunction from the plaintiff and listed plaintiff's then 2-year-old daughter on the instantly granted order of protection, which plaintiff asserts stemmed from hearsay from plaintiff's ex, which was never substantiated by any true evidence that would support the petition and further yield grounds to grant an order of protection, ceasing all communication between a father and his minor child. This also began May 1st, 2017, and coincidentally within the same hour as plaintiff was arrested for the disorderly conduct charge. On May 26, 2017, plaintiff was arrested yet again, ambush style, by 4 sheriff's deputies upon pulling onto the courthouse square in Oxford, Mississippi while he was pulling into a parking spot to go to a local bar in the square called the Round Table. Plaintiff had occasional communication with an individual by the name of Jimmy House, who allegedly resided in the Lafayette Springs area of Lafayette County. House claimed to be a supporter of Reardon and his cause. Plaintiff was going to be meeting House at the Round Table. For a beer, and this was going to be the first time that they would meet in person. Instead of finding House, however, plaintiff was met by Deputy Scott Mills, Major Allen Wilburn, Deputy Jared Bundern, and one other John Doe acting under color of law in making an arrest. Plaintiff never was told what he was being charged with. Meanwhile, his freedoms and liberties were jolted to an immediate halt, and it was then that the plaintiff's Fourth Amendment rights under the United States Constitution were immediately destroyed, and due process rights of the plaintiff was immediately disregarded as irrelevant to Lafayette County officials and employees acting under their official capacity, as the conspiracy began to grow and mutate. Plaintiff would find out later that the attorney, Mona Pittman, of his ex-girlfriend Phyllis Crowder, had filed a contempt motion yet again on the same day as plaintiff was arrested that month, and within the same hour, once again, plaintiff had also discovered that Miss Pittman had worked on the lower level of none other than Ray Tannehill, whom just so happened to be Crowder's child custody attorney, whom had multiple clashes with the plaintiff in court, and all evidence would lead the plaintiff to believing that conflict most certainly still existed. Plaintiff asserts clear motive to Mr. Tannehill's wife, Robin, slated for election as Oxford, Mississippi's mayor on June 6, 2017. Coincidentally, with plaintiff already slotted to speak and address City Hall over grievances. Plaintiff received communication of a death threat made to him, and on May 20th, 2017, Reardon purchased a Delton AR-15 rifle for a negotiated price of $550 from an individual named Larry Watkins, whom resided in Picayune, Mississippi, which Reardon met outside of Picayune to make the purchase. The following day, Reardon purchased a bulletproof vest, in the event the death threat was made to him was in fact true. The 22nd, Tannehill filed for emergency injunction, which was immediately granted by Judge Glenn Alderson, despite listing multiple examples of constitutionally protected activity that the suppression of such would cause irreparable harm, as it was constitutionally protected activity. Judge Alderson was more recently retired. On the 23rd of May 2017, plaintiff was stopped by sheriff's deputies on Ole Miss campus and presented with the order of protection. May 24, 2017, plaintiff spoke to Assistant U.S. Attorney Bob Norman about the latest move from the incoming mayor and her husband, along with the death threat made to him. May 25, 2017, the plaintiff met with the FBI in Oxford at arrangement of Norman. And on May 26, 2017, the plaintiff was arrested by Lafayette County Sheriff's Office for alleged aggravated stalking. Claiming honor before May 8, 2017, plaintiff put Todd and Ashley Lynch in fear of their life with an AR-15. However, plaintiff has the bill of sale proving he purchased the weapon on May 20th. And conversations with authorities and officials would prove plaintiff purchased the weapon because he himself was under duress from proof of a death threat sent to him via SMS text message. Plaintiff was held for nearly 96 hours before he was brought before a judge in order for bond to be set. This was a blatant ignoring of plaintiff's due process rights guaranteed under the Constitution, and plaintiff states that Justice Court Judge Carolyn Bell was quite likely the largest contributing factor due to her setting plaintiff's bond at $150,000, which is 3 times higher than the maximum guidelines called for under the Mississippi Rules of Criminal Procedure, which was readopted less than a year prior. Judge Bell refused to let the plaintiff address the court to give undeniable proof of his innocence. Plaintiff had never been accused of a felony crime prior, nor any violent crimes, and plaintiff believes political motivation was the driving factor in order to keep plaintiff silenced, restrained, and confined in the Lafayette County Detention Center until after the mayor-elect Robin Tannehill had assumed her office. A habeas corpus petition was filed in the circuit court by the Public Defender's Office on June 8, 2017, and approved to proceed that same day. However, plaintiff never was told any of this and was never brought before the court. Plaintiff was never allowed a preliminary hearing, which is part of the plaintiff's due process rights and requires that the accused be released on his own recognizance in the absence of one within 14 days. Plaintiff stayed confined until 1 week after Robin Tannehill was sworn into office, when he was pressured into saying he was guilty to avoid being railroaded by other false charges in order for the state to stick a win on something and get rid of the plaintiff. For 6 weeks, a presumably innocent man, veteran, sat confined and treated as a dangerous criminal. Meanwhile, being denied due process rights is guaranteed under state and federal law. All of this following a conspired upon plot to remove the civil rights of another, something most certainly deserving of a fair and honest investigation by the proper authorities. Yet it would seem that nearly everyone is not looking, not listening, or even worse, complicit, making it far worse. The complaint. Plaintiff brought this suit alleging Olive Branch Municipal Court employees baited plaintiff an hour away, allegedly with a predisposed plan to arrest and further financially burden the plaintiff due to his other ongoing battles with the state of Mississippi. In prior matter, in this court, the plaintiff was the victim of a false rape accusation in which the municipal judge let the accused walk free from her jail sentence if she paid the fine in full. Plaintiff was told he needed to travel to that court to get final court records and that the judge wanted to talk to him. Upon getting there, the judge called plaintiff to the stand in open court. threatened plaintiff with arrest if he called the court or came to the court again, and then asked the plaintiff what he wanted to address, to which the plaintiff responded that it was his ex, and that if she was let off the hook, that he created a monster whom was enabled, at which point plaintiff was cut off and jailed for contempt by the judge simply for doing exactly what the judge asked. Plaintiff alleges this was a false arrest which deprived him of his freedoms and liberties. Plaintiff hereby respectfully prays upon this honorable court to grant this case the special privilege due to its complexity, in which plaintiff is appointed counsel that can further assist this matter. Respectfully submitted this 25th day of February 2021, Matthew Reardon, the Oxford Outlaw.